Stephen Brown, Etienne lawyers. In this particular session, we're going to look at intellectual property. And the reason we're going to be looking at intellectual property is that as lawyers, we come across various forms of intellectual property when we're engaged with setting up businesses for our clients, in the sale of those businesses, in the expansion of those businesses, in looking at taxation aspects, in looking at family law matters, and in the unfortunate situation of deceased and probate estates when someone dies. So we need to have an understanding of what these particular creatures of statute are all about. Now, the particular creatures of statute we'll be talking about arise from various pieces of legislation. The term intellectual property governs numerous issues and numerous laws, and they are all creatures of statute, with the exception of confidential information. So when we say intellectual property, what are we really talking about? We're talking about such things as copyright. We're talking about such things as patents. We're talking about registered designs. We're talking about trademarks. We're talking about domain names. We're talking about confidential information and integrated circuits. And the concept of intellectual property can really be described as the ray of white light from this torch, which can be seen on the screen. And when it's put through a prism, the white light, the bundle of rights, as that we describe as intellectual property, are broken up into its constituent elements of copyright, patents, registered designs, trademarks, domain names, confidential information, integrated circuits, and plant breeders' rights. So in the session, we'll talk about a number of particular types of rights, and we'll have an overview of what they are. The first form of right that we'll look at is copyright. Copyright is a creature of statute created by the Copyright Act of 1968, and copyright protects the expression of an idea, not the idea itself. So if you have an idea, if you were the person that thought of a franchising system, the mere fact that you wrote out the entire system in writing, the expression of your ideas as authored by you would be protected by copyright. However, the exploitation of the ideas embodied within your work is not protected by copyright. Consequently, when you go about and create the particular process, having the first McDonald's, having the first KFC, competitors can come in, and provided they do not breach your copyright or breach some other form of intellectual property, they will be able to effectively compete against you. Now, the types of things you need to consider with copyright is registration required. Under the Copyright Act, registration is not required in Australia. Copyright is created as soon as the particular work, which is authored, comes into being, whether that's known or not known. The duration of copyright is the life of the author, plus, in most cases, 70 years after the author's death. It was previously 50 years, but on January 1st, 2005, as a consequence of Australia and the US entering into the Australia-US Free Trade Agreement, the term of 70 years was adopted to make it consistent with the duration period of copyright within the United States. Copyright, like any form of property, can be transferred, and it is usually transferred by written agreement. Indeed, the Copyright Act requires that any transfer of copyright be in writing. So there is a legal requirement that there be writing to legally affect the transfer of copyright. There are international patents or trade treaties that apply and the numerous treaties that apply that extend mutual recognition to copyright created in Australia to overseas are those covered under the Berne Convention for the Protection of Literary and Artistic Works, the World Trade Organization Agreement on Trade-Related Aspects of Intellectual Property Rights, known as TRIPS, the WIPO, World Intellectual Property Organization Copyright Treaty, the WIPO Performance and Phonographs Treaty, the International Convention for Protection of Performers, Producers, Phonographers and Broadcasting Organisations, known as the Rome Convention, and the Convention for the Protection of Producers, Phonographers against unauthorised duplication of their phonographs, known as the Geneva Phonographs Convention. So as you can see, it's copyright, although created in Australia, is given international recognition, and again, it's as of right. The duration of copyright will depend upon what it's used. The general rule is the life and being of the author plus 70 years. And as you can see from the screen, there are a number of particular provisions dealing with engravings, artistic works that have slightly different duration periods. There are some special rules dealing with copyright, and they are important for you to have an understanding of if you're dealing in this area on a day-to-day basis. Now, another issue that's important to understand is the issue of authorship and how copyright is created. A particular matter that came across my desk a few years ago was this particular matter of Australia's First Choice and a company called ASME. Now, what happened in this particular instance was that the Australia's First Choice group engaged a contractor to draft for them an operations manual. And the contractor was engaged, they created the operations manual and were paid the appropriate money. The organisation commenced using it. A number of months later, the contractor, not being successful in their contract as working as an independent contractor, took on the role of a full-time paid employee of ASME. As a paid employee of ASME, they were tasked with the job of creating for ASME an operations manual. Being the legal owner of the copyright previously created by the Australia's First Choice group, the author decided to use the basis of their intellectual property, their copyright, to create a work for ASME. In doing so, the second work was produced. The Australia's First Choice people, when they found out about this, sought to injunct ASME from using what they said was their copyright. They were not successful. And they were not successful for two important reasons. First, the contract that they had with the contractor, whilst it gave them a particular product, it failed to actually assign to Australia's First Choice the ownership rights of the copyright that the author had produced. As there was no express assignment of the property in the copyright from the author to the Australia's First Choice group, whilst the Australia's First Choice group had a license to use the intellectual property, that copyright, they didn't own it. They needed to actually have within their contractor's agreement an express assignment clause. This failure meant that the copyright still vested in the particular contractor, such that the contractor was at liberty, at law, to use their own intellectual property for ASME. The interesting point to note is that when creating the work in the capacity as an employee for ASME, the copyright automatically vested in ASME, and it was therefore lost to the particular contractor. So ASME was the owner of the copyright, whereas the Australia's First Choice organisation merely had a right to use the particular form of copyright that had been created for it in the first place. So it's important to understand who is the author of works. So when works are being created within a client's organisation, there needs to be a clear audit trail as to whether the works were those of an employee and ensuring that that work is noted. If it's being created by an contractor, the questions one needs to ask is the intellectual property to be assigned? If it is to be assigned, is there an express written assignment provision within the contract, or does one need to be produced? Otherwise, you can find that your client will be in the Australia's First Choice and ASME situation. Another form of intellectual property, again a creature of statute, is that of a patent. Now, a patent actually protects an idea. The idea, though, must have a practical use. It can cover a novel manner of manufacture. An idea, though, it must not be so obvious, but it must, to obtain a patent, either as an innovation patent or as a standard patent, the downside is that the actual full knowledge of what the idea is and the manufacturing process must be disclosed. The rationale is that in order for a government to grant to a patent holder a monopoly right for a period of years, the knowledge which is embodied within the patent must be given to the world at large for mankind's knowledge base to expand and to grow, thereby allowing other people to leverage off that bank of knowledge. So that's the quid pro quo of obtaining a patent, is the possibility that you will have to lose the rights because by disclosing the information, another person will be able to leverage off what you've discovered to improve your system, provided that in doing so it was not an obvious extrapolation of the concept. Registration of a patent is essential. Unless and until the patent is registered, you have no rights that are protected. In Australia, there are two forms of patents. There is what is known as a standard patent, which requires a full examination procedure for the patent to be granted. The period for a patent is 20 years, provided the annual fees are maintained, and 25 years for pharmaceuticals. There is an easier form of patent, known as an innovation patent. The monopoly rights are granted, though, only for an 8-year period. The benefit of an innovation patent is that there are lower thresholds of inventiveness, and the costs of obtaining an innovation patent and the approval process is much quicker and speedier. The problem or challenge, one may say, with an innovation patent is that you are not able to seek to enforce an innovation patent unless and until it has been examined. So if you have the patent and it's not challenged, then the monopoly rights will be there. However, if you obtain an innovation patent and should it be challenged, or should you wish to seek to injunct a third party from using what you perceive to be your patentable rights, you need to first have the patent examined before you can proceed to any enforcement. With copyright, as with copyright, an assignment of a patent needs to be in writing. All or part of a patent can be assigned. Other than that, there are no legal requirements. Similarly, there is a universal or international recognition of patent protection through the Patent Cooperation Treaty Registration Pact. These particular treaties, be it for copyright, patent, trademark, and the like, only apply to the countries that are signatories to the treaties. Accordingly, it is important to find out which countries are signatories and which aren't. Unlike copyright, which exists as soon as the work is created, with the patent, which requires registration, in order for your clients to obtain proper protection, you first need registration in Australia, and the patent is only protected in those international countries in which you have equivalent registration. So, for example, if your client was looking to manufacture and sell in the United Kingdom but not America, then arguably they would need only to get the patent in the United Kingdom and not necessarily in America. Query whether the rights of parallel importing would need to be assessed, and that's something you would need to take greater concern as to give your client the necessary degree of advice as to what areas and what countries registration is required. Registration of patents is not an inexpensive process. Because of the examination, it is quite rigorous, and the costs of obtaining patents can be quite expensive. To illustrate what a patent is a novel idea, device, substance, or process capable of industrial application. An example is the Open Market Inc.'s Internet Payment System, which was created in 1998. Similarly, it's the one-click shopping trolley. We've all seen on websites where there's trolley, basket, click, and the process. That entire software program was able to be patented in the United States. Similar patents have been available in Australia. Unlike Australia and the United States, the European Union did not accept, though, that the basket process was patentable. So the laws of intellectual property, being creatures of statute, do have nuances between countries, and those nuances do need to be recognised and considered on a regular basis. One of the other forms of intellectual property, also a creature of statute, is that of a registered design. Under the Registered Designs Act, a design refers to features of a visual nature of the shape, configuration, pattern, or ornamentation of two-dimensional or three-dimensional commercialised products. The registration protects the visual appearance of a product, not its use, not the ideas behind it. It's purely how it is structured, how it looks, how it feels. The registered design gives legally enforceable rights, again of a monopoly form, similar to that of copyright and those of patents. The period for a registered design is a maximum period of 10 years that arises from an initial period of 5 years with a right to renew for a further 5 years upon the payment of the appropriate renewal fee. Like copyright and patents, a registered design to be effective must be registered, and any transfer is by written contract. International protection is achieved through and under the Hague Convention. So if you've got any interest in registered designs, consider the Registered Designs Act of 2003. The process is relatively simple. We can see a striking pair of Speedos, which has been subject to the design. The design covers the pattern, the picture of the Speedos and its actual shape, and lasts for a period of time. An example of registered designs, or an area that you need to consider, and a particular issue which illustrates the challenges of creature of statute, again came across my desk a few years ago when there were some guys who had devised a new and improved fin design for a surfboard. And they went out and they designed this fin and obtained a registered design in Australia. Having obtained the registered design, and without seeking any legal advice, they took their new boards to a competition in Brazil. And the guys did really well, and a number of people were asking them why their boards were performing better than their competitors, and thinking that their rights were well and truly protected as a consequence of the Australian design registration that they had obtained just prior to them leaving Australia, they extolled with great delight and joy the benefits of the particular design of their fin, showing everyone the new design of the fin. Brazil is not a member of the Hague Convention, and Brazil, being an ex-Portuguese outpost, colonial outpost, although no longer the case, a number of people were from Portugal. They went back to Portugal, who was also not a member of the Hague Convention, and obtained proper advice there, and were able to manufacture by copying our client's registered design, and started to sell surfboards in Europe, America, and the United Kingdom. The guys came back to us and said, look, we've now discovered that we've now got competitors who are blatantly ripping off our design. What can we do? And regrettably, I think the technical advice we gave them was bugger all, as a consequence of the fact that registered designs, being creatures of statute, are geographically specific to the jurisdiction in which they're registered in. What they needed to have done was to have lodged geographic parallel registrations in all of the countries in which they were likely to want to market at any point in time. Their only rights were to prevent anyone competing in Australia and to prevent the people overseas who had the larger market from importing their competitive fin design surfboards in Australia. So it's very important for you and your clients to have an appreciation, or for your clients to impress upon them the need of the geographical limits that these monopoly rights created through statute give rise to. Another example of a registered design is this of a particular block, similar to Lego but not Lego. And another item to remember is that we had another case again a few years ago with a registered design, that they can be very innovative, and as lawyers we need to sort of give business advice to our clients on concepts of innovation and business projects. A client came to us and said, look, we make extraction systems for mines. There's a lot of heavy metals and minerals in dust, so that when a coal mine is being, underground coal mine is being mined through with these great big mining wheels, dust comes up. And heavy metals such as gold and silver can be within the dust. And if they're not extracted properly and refined, the potential value of those minerals is lost. So this company had devised an extraction system which would take the dust from the air, run it through a filtration system to extract the heavy minerals to give a better return to the mine owners. The model initially for the client was that they would have a cost recovery with profit for the installation of the process. However, they were finding a lot of market resistance with mine owners because the initial upfront costs the mine owners didn't wish to expend, and therefore were reluctant to put the particular system into place. So their board and management marketing people came up with the concept that they would install the systems below cost, have a signed up contract, and then try to make the profits from the filters that needed to be replaced on a regular basis. The concern they had was that if they were only going to get their profit from this long-term process, how could they protect the filters in such a manner that a third party didn't come along and produce a generic filter at a lesser price, thereby robbing them of their future profit and indeed even making good their initial instalment costs. So we worked with them and we came up with the idea that what they should do is have a locking mechanism that was a registered design. So design a locking mechanism in such a novel way that at least for the 10-year period that the design lasted for, they would not have a competitor that could generate a product without infringing their design for which they'd be able to get an injunction over. So they went ahead with the process. We obtained the design for them. They went through, they got a number of clients up and running, and as the inevitable would happen, a third-party organisation did start to replicate the filters, and they started to be imported from China. They then obtained a couple of them, the filters, to discover that yes, they were copying and using their registered design, so much so that the imprinted registered design registration number that they had been totally copied. So clearly we were able to establish an infringement of the registered design under the 2003 Act, and we were able to get injunctions and the appropriate damages from them. So you can be very innovative by using intellectual property to protect your rights, but you need to consider it as a bundle of rights, not just as one level of protection. Another form of creature of statute is that of a trademark. A trademark is a badge of recognition of a product or service. A trademark can be that anything of something that's visual. It can be a sound, that sound you get when you open up your computer in the morning. Microsoft have trademarked that. The sound of a Harley Davidson motorcycle has also been trademarked. Smell, bouquets are trademarked. Shapes, particular shapes of bottles. There are particular champagne bottles. Bollinger, for example, have created their normal 750ml bottle into an equivalent shape of a magnum. They believe that the shape of a magnum puts it under greater pressure, thereby giving a greater bouquet to the champagne when poured out, and they have a particular trademark on their 750ml bottles. So it's important to consider how you can have a badge of recognition for your particular product or service and protect it. And trademarks are an excellent way of doing that. The form of trademark can be a graphic design, such as the Pringles head of a man with mustache and bow tie cartoon. Trademarks are registered in particular categories. There are currently 45 particular categories. Predominantly they are goods categories, and there are about 5 to 6 service categories. The issue with trademarks is that you need to have the proper registration of your good or service in all requisite or necessary classes. For chips, it can be easily one. However, for a restaurant that is preparing food, selling food, having sit-in meals, takeaway meals, if they're also selling sauces and the like, there can be up to as many as 6 or 7 classes in which the same mark and or marks need to be registered. The registration process is relatively simple. The costs are not that expensive, but they are certainly worthwhile having. As with a patent, copyright, registered design and trademarks, all of these creatures of statutes create personal property rights which vest in the registered holder of the intellectual property. They are rights which can be sold. They are property rights which can be mortgaged under the Personal Property and Securities Act. They're rights that can be sold. They're rights that can be licensed. So they're very valuable. And the goodwill that attaches to the particular use of a trademark goes to the trademark owner, not to the user. So if you've got a franchise system, McDonald's gets an accretion in value to its goodwill each time its franchisees use the McDonald's trademark, get up, design and the like. So you can expand exponentially the value of a system by having a proper registered trademark. And we need to bear this in mind, and we'll have a later discussion throughout the course on the difference between a business name, a domain name and a trademark a bit later on. Trademarks are a unique creature of statute in that, unlike copyright, which has a life of the author plus 70 years after their death, patents, which can be for 20 years or 8 years, registered designs, which are 10, trademarks are forever. So long as you keep on renewing and paying your renewal fees, which at the moment is every 10 years, the mark will go on for in perpetuity. For example, Coca-Cola, Pringles, Holden, Ferrari. These names are great, all registered and have a duration of much more than 20 or 30 years. So it's quite important to recognise this. International mutual recognition of trademarks arises under the Madrid Protocol, but like registered designs and patents, it is geographically jurisdictional based registration that is necessary for a trademark to be acknowledged within a separate country. So if you wish to have a mark recognised in New Zealand, it must be registered there. If you wish to have it recognised in Singapore, it must be registered there. So if you're likely to want to use a mark overseas, you need to consider what areas it will be used. There is some argument that by using a website which goes through around the world, you might be using it internationally. Query whether that is in fact the case if you're in fact not supplying any goods or services, but it's merely visible. There are case law as to whether mere visibility is use. So you need to give some thought as to whether you wish to be more expansive and actually have some sales within particular geographic jurisdiction and get registration or not. These are issues you consider. A lot of clients have the wrong belief that by registering a business name, they own that name. Section 17 of the Business Names Registration Act of 2011 expressly provides that you have no property. The registered user of a business name does not acquire a property right in a business name. The purpose of business name registration is merely to ensure that people who are trading, or an entity that's trading under a name not their legal name, can be found, and to prevent confusion between two or more other parties using similar or like names. So if you wish to have a proprietary right, which by extrapolation will necessarily have the right to attach goodwill to it, trademarks are the way to go. It is arguable, depending upon how a business name is used, that a common law trademark may arise through the use of the business name, but registration of a business name per se will not give the registered user of that name any proprietary or property rights. So getting a trademark of a name is more beneficial than anything else. So have a look at sections 20, 21. For instance, section 21, subsection 1 of the Trademarks Act 1995 expressly states that a registered trademark is personal property to the register owner of that mark. Confidential information. Unlike the creatures of statute that we've previously been discussing, confidential information arises as a matter of common law and equity or contract. Confidential information must be information that is confidential in fact. It must be information that is kept secret and not known to other people. The prime example of confidential information is the formula of Coca-Cola. For over 100 years, Coca-Cola has been able to maintain its formula to be secret. True, with today's ability of having mass spectrometry, people in labs would be able to put it through a mass spectrometer and actually ascertain what the formula would be. However, they can't produce a product and say this is like Coke, that we're using the formula, because that would be reverse engineering. It would be the disclosure that they had breached the confidential nature of the product, and therefore they wouldn't be able to sell it. They wouldn't be able to say it's like Coca-Cola, because that would also be an infringement of the trademark. So having something that's secretive may, in some instances, give you a greater longevity for monopoly, or at least oligopoly rights, than what obtaining a patent would be. This has been recognised by a lot of pharmaceutical companies, whereby base patents are being obtained, but the nuances around the processing, the patents are not being sought, and the pharmaceutical companies are seeking to retain the information in-house, thereby giving them greater longevity rather than having a 25-year period. Whether you should have a patent or whether you should try to seek to maintain the information as confidential will depend upon how easily it will be to be discovered, or how easily it might be discovered inadvertently through a third person elsewhere. To illustrate the fact that information must be per se confidential or secretive, take for example the situation that you look at the front page of the Financial Review and a person gets that front page, calls an employee into the office and said, "I've got some information which I wish to impart to you. I can't tell it to you unless you sign a non-disclosure agreement. Will you do that? Yes, the person says. They sign the non-disclosure and then they are given, within an envelope, the front page of the Financial Review of today's date. There is no way a court will uphold the nature of that non-disclosure agreement, because the very nature of the information that is sought to be made confidential or secretive is already in the public domain. Information that is known in the public domain can't be, even by contract, rendered secret or confidential. So in order for something to be confidential information, it must be closely held by a few people within an organisation. A case we had a number of years ago was where an employee, a key employee of a hairdressing salon, moved across the road. The client didn't have a restraint of trade provision, and the employee was ringing up clients. It was discovered they were ringing up clients because the clients were ringing my client up saying, "Oh, what's this telephone message I've had?" And my client hadn't been phoning them, so it was discovered that the person that had been phoning them was the ex-employee who had set up a hairdressing salon diagonally opposite across the road from them. Now, the question was, clearly they had removed the client register and details. Was that register and details confidential? One would think prima facie that it is. However, in this instance, we had to advise the client not to commence any action for an injunction on using the list, because what happened in this particular client's business was that the information of all clients was freely available to everyone throughout the entire hairdressing salon, including the receptionist. It was never kept under lock and key. It was never password protected, so the information was clearly available. And therefore there was an argument that we couldn't establish that they'd taken a list. It was possible that the particular person may have kept it in their memory, and therefore the cost benefit of taking an action simply wasn't worth the while. What the hairdresser had to do was to put into place a system to protect and maintain their confidential information, so that should this unfortunate event arise again, they could then take injunctive relief against them and to instill or to create within the contracts of employment non-compete and restraint of trade clauses. Being not a creature of statute, there's no registration of confidential information. The duration of the confidential information is forever, or at least whilsoever it is maintained and kept secret. There are no legal requirements to assign it. Written contracts are generally used, and there is no uniform international protection. The regard needs to be had to the particular jurisdiction as to what can be kept confidence between America, England, New Zealand, Singapore and the like. So we need to do it on a country by country basis. Have some regard to the steps to take to protect and maximise the secrecy of confidential information. Clients should be advised to enter into confidentiality agreements with all employees and others who seek to have access to it. There should be an adequate record of what confidential information employees have access to. For example, if you are designing a new system, in most pharmaceutical labs, to maintain the secrecy of what's happening within a particular lab, who enters the lab, when they enter the lab, and when they exit is all documented. These days the process can be digitalised by access keys, but having records of whoever went in to a particular lab can be crucial. For example, if only 5 people ever went into a lab and one of those 5 left the company and 12 months after leaving started to produce a competitive product, then more likely than not, they may be using the intellectual property that they obtained whilst working with the first company. However, if those 5 people are not one of the persons who starts to create a competitive product, it's arguable that the information has been independently derived through concurrent research through a totally independent process, and therefore won't be able to be protected or injuncted by you. So having a record of who knows what is crucial. Other steps to take are fairly common sense approach, but if something is confidential, mark it as such. It can be very difficult to convince a court that you, through a client, purport that a document is confidential if you can't show that the client treated it as such. It's very difficult to enlist the aid of a court to take your side or client's side if you can't prove to the court that you genuinely treated the information as confidential. Establish and enforce security procedures appropriate to the place of work. For example, the level of restraint of trade for a senior executive should be much more robust and strenuous than it would be for a receptionist or secretary. Ensure employees, suppliers and customers take all steps available to them to inform anyone as to what information is or is not confidential at any time. Keep adequate records before negotiations start to commence. Make sure non-disclosure agreements are entered into, and as twee as it really may be, just like as lawyers when we're entering into negotiations, we use without prejudice, save us the cost, and we're very diligent in doing that. In sensitive negotiations, you should always make sure that you start the conversation by saying, now please note this is a confidential meeting and what is being discussed and described here is to be maintained and kept in confidence, and do the appropriate file note for this particular situation. The other form of intellectual property that we can move on to is that of circuit layout rights. Circuit layouts arise under the Circuit Layouts Act of 1989. What are circuit layout rights? A circuit layout rights automatically protect original layout designs for integrated circuits and computer chips. The rights are created on the creation of the design. Registration is not required. While these rights are based on copyright law principles, they are separate and are a unique form of intellectual property protection. There is no requirement for registration of the granting of the rights to the owner for a layout design. Circuit layouts are usually highly complex, and the intellectual effort in creating an original layout may be considerable and of great value. An integrated circuit or chip made from the plans is the key to the operation of all kinds of electronic devices, from heart pacemakers to personal computers. The owner of an original circuit layout has the exclusive rights to copy the layout in any material form, make integrated circuits from the layout that has been designed, and to exploit the particular layout commercially. The period of time that the monopoly rights are given will depend upon whether the layout design has been commercially exploited or not, but they are 10 years from each period. There are conventions in which there are treaty parties, and again these are geographically and jurisdictionally based. Another form of right is that of plant breeders' rights. Plant breeders' rights are used to protect new varieties of plants that are distinct, uniform and stable. This form of intellectual property is created by the Plant Breeders' Rights Act of 1994, and they are there to stimulate investment, to allow people, organisations such as Monsanto, to develop new and improved varieties of products. To be eligible for protection, the plant breeder must show that the new variety is distinct, as well as being uniform and stable. That is, it reproduces itself in the same colour, same format on year by year. So it doesn't have great changes of variety occurring. To demonstrate this, there has to be comparative trials which are undertaken, and a particular person of the organisation needs to be appointed to deal with IP Australia, Department of Agriculture and the like, to ensure that the particular stability and longevity is there. If you have a right, you have 12 months from the time of first exploitation, commercial exploitation, to get it registered. If you don't, then your rights to seek registration of a plant breeder's right will lapse. IP Australia is the registering principal body, and you need to contact them such as you would with a patent, trademark or registered design. The period of duration is 20 years for plants and trees and 25 years for grapevines. Any assignment needs to be by writing, similar to copyright, and there are international protection provisions under the International Convention for the Protection of New Varieties of Plants registration. Again, geographically, jurisdictionally based, so if you're seeking registration in other countries, then you need to have the separate registrations to obtain it. To manage a plant breeder's rights involves paying annual registration fees, correctly labelling the plant in accordance with the provisions of the Act, commercially exploiting the particular plant if you wish. You can use it yourself, or you can promulgate it for sale. And there is a positive obligation of you to excluding other people from specified acts within the Plant Breeders' Rights Act in relation to the particular plant breeding that you have registration over. Another form of right, and I use the term loosely, is that for domain names. A lot of people in business treat domain names in the same manner as they treat business names, taking them as some form of proprietary right. They aren't. The right to use a domain name is a contractual one, and it's a form of license from the Domain Names Registry. So you have a right to use it, and you can transfer those rights, but you do not own the name. The particular name that you attach to a domain name can be challenged if it isn't yours. If you seek to use a mark which is another person's trademark, or a name that is deceptively similar to another person's trademark, the particular domain name can be challenged and your right to use it can be removed from you. So, having seen what intellectual property rights there are, what's the value? The material or monetary worth of anything is what it can be exchanged for. The price that would be negotiated in an open market, an unrestricted market, between a knowledgeable, willing but not anxious buyer and a knowledgeable, willing but not anxious seller acting at arm's length. The Crown and Spencer principle. And that applies again to intellectual property. The difficulty with a lot of intellectual property is that when it's first created, there's no longevity, no history of maintainable earnings. Everything's in the future. And the creator normally has overly unrealistic expectations of its worth, whereas someone wanting to exploit it have probably more realistic expectations and don't want to pay too much. And coming to a meeting of the minds in those situations is a requires a lot of legal as well as practical gymnastics. The accountant's definition of value is to look at the hypothetical purchaser who is willing but not anxious, fully informed of the relevant facts, a prudent, not risk-taking person, willing to pay a fair price rather than miss out, willing to invest in anything available in the market, and is only concerned about a tax-neutral form of investment. That is, the investor has no tax incentive or disincentive which might bias their investment decision in favour of or away from a particular investment. The difficulties in valuing intellectual property is to identifying and segmenting the intellectual particular property. Remember, they are creatures of statute. Remember, they are geographically and jurisdictionally specific for copyright, trademarks, patents, circuit layouts, and plant breeders' rights. Assigning value can be very difficult. The valuation methodologies consider comparable market transactions, historical replacement costs, valuation of the business less tangible assets, relief from a royalty method, capitalisation of historical profits, or using a discounted cash flow or net present value and analysis. And it's really beyond the scope of this particular session to go through these methods in detail, but noting that they do exist and to give you a course of inquiry into investigation. The more preferred methods are those of comparable sales, net present value, and relief against royalties. Also consider the tax aspects of intellectual property. For some particular reason, although circuit layouts are creatures of statute and registered and plant breeders' rights are creatures of Commonwealth statute, the definition of intellectual property within the Income Tax Assessment Act only refers to intellectual property as meaning a patent, a registered design, or copyright. So why there is that limitation, I don't know. Some other issues: consider the deductibility of grants, consider the cost of acquiring intellectual property and what it's put into. The session has shown you that you need, from just everyday activities of dealing with clients that have anything to do with the business, the need to have an appreciation and working knowledge of the various forms of intellectual property, how it can be created, how it is protected, how you can challenge it if you believe someone is infringing upon rights that your client has and might be exploiting elsewhere. And we've had a quick look at the valuation concepts of what intellectual property can be attached to and how it can be looked at.